Hey everybody, welcome to Thursday night. John Skiba here from the Consumer Warrior YouTube channel. I used to say like I am each and every Thursday night, but you know what? It's been a little while since I've been here. So I apologize for that. Summer gets a little bit crazy. A lot of stuff going on, but I'm back here in the seat again for this live Q&A on a Thursday night. For those of you who are new to the channel, again, my name is John Skiba. I'm an attorney in the state of Arizona, and I help people who are dealing with serious debt problems. And that was the whole idea behind the Consumer Warrior YouTube channel, was to provide information, tips, strategies, and really just some general direction as far as how to deal with things. We always go to the worst place in our mind thinking, you know what, hey, I'm going to end up in jail because I can't pay my credit cards or whatever. I'm here to tell you that's not the case. You're going to be okay. We can put a plan together. And so what I like to do on Thursday nights is just open it up for questions. If you're watching on YouTube or Facebook, go ahead and put a question in the chat section. I'll put it up here on the screen and we'll talk about it. My general disclaimer each and every week is that I am a licensed attorney in Arizona. I'm not licensed anywhere else. This isn't legal advice. It doesn't create any type of attorney-client relationship. This is just some guy talking on YouTube. So take it for what it's worth. If you need specific legal advice, you can contact my office if you're in Arizona, and I can do a consultation. I'll actually, in the chat, I'll put a link to how you can get hold of me. Let's see if I can put that in the chat without causing too many technical difficulties. I'll put that in there so you can hit a link. If you're not from Arizona, put it in there anyway. We can direct you to some people that can help you out. So, oh, and I also need to mention in the chat section, you'll see links to our sponsor of the weekly live stream, Solo Suit. They have some great resources and technology that can help you if you're dealing with a debt collection lawsuit or if you need debt settlement or any of those types of things. Go check them out. They can help you out as far as preparing documents, submitting them to the court. And it's a great, affordable resource, particularly for cases where sometimes it doesn't make sense to bring an attorney like myself in. You know, if you're getting sued for $500, it's not going to make a lot of sense. It's going to cost more than that to defend the suit. It's a good way to reach out and kind of get the thing squared away. So, yeah, so if you do have questions, go ahead and put them in the chat section, and we are going to jump into them here pretty quick. Rob was here nice and early. Asked him how he's doing. He says it's going. It's not near as hot today here in Ohio. Yeah, we're in the miserable season here in Arizona. It's usually 110 plus. You know what? I was looking on my phone earlier today at the overall. I know you didn't come here for weather, so we'll just jump into it quick. Man, the 10-day forecast, it is going to be 110, 111, 108. So things could be worse, I guess, when it comes to weather-wise. All right, let's jump in here. Scott says, regarding debt settlement, who is required to file for arbitration in Arizona? Can the debtor be required to file? So, Scott, I think you're probably referring to like compulsory arbitration when it comes to debt collection lawsuits. This is a really common question and kind of a misunderstanding. And if you watch my channel a lot, if you've watched it for the years that I've been on, you're going to see that even I have morphed a little bit as far as my position on this. Just for the background. So any of you that are dealing with debt collection lawsuits where credit card company has filed a lawsuit against you, it is possible to get it thrown out of the court and into what's called private arbitration. There are these companies out there, private arbitration companies, JAMS and the American Arbitration Association, AAA. They are private companies. They're kind of like a hire a judge kind of thing, where you can reach out to them and they will help you to resolve your dispute, and it can be binding on the parties. There's a lot of reasons that parties want to go to arbitration rather than the court system. But you as a consumer can actually elect to take your case out of the court system, put it into private arbitration. The way that you do that is, one, you have to find out if you have an arbitration clause in your credit card agreement. And that's where you get the terms and conditions of the card and look and see if there's a private arbitration clause. If you don't have access to your credit card agreement, you know, let me just pull it up really quick here. The Consumer Financial Protection Bureau. Consumer Financial Protection Bureau. I'm not going to be able to get it up here. I'll put a link in the notes afterwards. It's a governmental agency. They have a whole database of credit card terms and conditions. You can download yours for your specific card there and see if it has it. If it does have an arbitration clause, you can file a motion to dismiss your case and compel private arbitration. And the question then is, once the court says, okay, it's in the contract, you can go do arbitration, then the question of is who initiates the arbitration? And I used to take the position in the past that the creditor should be the one to initiate arbitration. They're the ones suing you. You're not suing them. It seems kind of weird that you would initiate essentially a lawsuit against yourself. But that is the position that I now take. The reason is because what I dealt with, and I even dealt with in my own practice here in Arizona, where the court would say, okay, go do arbitration. You have 90 days to do it. If you don't do arbitration in 90 days, then we're going to go ahead and allow the case to move forward. At that point, if they, and Scott added a question on there saying that the attorney agreed with compulsory arbitration, however stated, I must file. So it's okay for you to file is my whole point of it, because a lot of times the creditor's attorney will not do it. And then you have to go back to the judge, and the judge is going to be like, why didn't you file the arbitration? And it tends to backfire a bit. So there's no downside to doing it. You can file the arbitration yourself, and then you'll be fine there. So Scott, I think you're doing everything exactly like you should be doing. All right. Hercules says, I'm in the discovery phase of a trial against DNF Associates, assignee of Continental Finance. So far, they've only produced a bill of sale and billing statements. What strategy do I recommend for this stage of discovery? Specifically, what types of written discovery requests should I pursue to strengthen my case? So let's go back to your first comment there. So far, they provided a bill of sale and billing statements. I always say, look at those things really closely. Really pick apart the bill of sale. Look and see, does it reference just a general transfer of unnamed debts, which most of their bills of sale do. They don't reference, that Hercules count is being transferred. They just say, this pool of accounts are transferred and it's attached as Exhibit A. And often there's no Exhibit A, or there's like a redacted Exhibit A that doesn't include all your information. So double check that, because not only does a debt buyer like DNF have to prove that you had the original account with Continental Finance, they've got to show that it was your account was assigned or transferred to them, not just that a big pool of accounts were. Go and look at the billing statements. See if they've accounted for payments and purchases, interest rates, look, all that kind of stuff. I don't see it as often, but I used to see statements where I would even go back and look at the advertisements. A lot of credit card statements have ads on them for whatever, cell phone plans or whatever. I would find statements where the ads did not match the billing statement. And what I mean by that is the billing statement would be from 2001, but they had like a thing for the iPhone 15 on it. And, something that didn't exist at the time that statement was printed. You can use that to show the court that these are not original statements. These are just some recreation that they did, and try to get them excluded. So go over everything with really a fine-tooth comb on that and determine if what they already provided you is even enough. Now, as far as the written discovery stage, so in civil lawsuits, you have the ability to send over written discovery and request documents, request information, request for admissions, those kind of things. It's something where they can do that to you as well. They can ask for that information. Now, the issue with this, I always say this. I understand the idea of like, hey, I'm going to make them provide me with everything they have. You're the defendant in the case. In a civil case, the defendant does not have to prove anything. You don't have to disprove that you own it. Your job is to really sit back and let the plaintiff, who bears the burden of proof, they have to prove all of those elements. They have to prove that you opened up the account, what the terms are, what the balance is. They have to prove that it's something where, like I said, it was specifically transferred or assigned to you. They have to go through all of that. You don't have to disprove it. And so they have to have documentation to do that. And what I have seen is I've seen consumers, defendants who send over a request for production of documents or interrogatories, and the creditor doesn't have that from the original creditor. And to fulfill their obligations under the discovery rules, they actually end up going back to the original creditor, getting documents that they didn't have, and it actually strengthens their case. So I always say, be careful what you ask for. I typically don't do a lot of discovery just because the less evidence they have, great. If they want to try to show up with a generic bill of sale and a couple statements, great, we'll do this. It's not something that has to be, where you're requesting a bunch of information, because you may actually be helping them in the long run if you do that. All right. Joseph said, Amex sued me for non-payment of a personal loan, $15,000. They did not serve me in 120 days. The court gave them 60 days more. Still no serve. The court dismissed the case. Do you think they will refile? It's one of those things where this is common, by the way. At least here in Arizona, where I practice, you'll see debt collectors will file thousands of lawsuits each and every month. And most of them, or at least a good portion of them, end up getting dismissed for failure to serve timely. So they file the lawsuit, the complaint, then they have to hire a process server, a constable, sheriff. They go out and, they have to come by, knock on your door, serve you with the complaint and the summons. And then the time comes for you to start responding to it. The rules require, though, in some courts, it's 120 days. Some courts, it's 90 days. And if they don't do it, they can ask for an extension like they did here. And because they didn't serve you timely, the court dismissed it. When the court dismisses it for failure to serve timely, it's dismissed without prejudice, meaning that it can be refiled if the statute of limitations has not expired. So the first thing I would look at is, when's the last time you made a payment on this? They have, in Arizona, the statute of limitations is 6 years from the time that you stop making payments on it. I can tell you the American Express, they typically don't sell their debt, and they tend to be more aggressive. And so usually I see American Express lawsuits filed within 12 to 18 months after the account was charged off, or even after the last payment was made. So it may be, I've kind of given up on guessing when if they're going to be refiled, because a lot of it depends on not only the creditor, it depends on the law firm, how diligent they're being on it. They could, usually for lack of service, I do see cases frequently that have been dismissed, and then 6 months later they get refiled. Just know that the statute of limitations is ticking. And that whole time when they had it pending, that doesn't count anymore. That counts towards you. That's to your benefit. So it's still something you may be able to use down the road. So, all right, let's see what Rogelio, hope I said that right. I missed the day of the mediation and requesting to reschedule it. Is this a good idea or a bad idea? Good idea. If you don't show up to mediation in most jurisdictions, they're going to allow the creditor or the plaintiff to seek a default against you. You don't want to default. Anytime, whether it's, filing an answer, showing up to mediation, summary judgment, whatever it is, default means that the court's going to give them everything that they're asking for. And not only that, but they usually give them attorney's fees, court costs. So I would ask the court to reschedule it. I would just call the clerk up. They may require you to file a motion, maybe explain what happened as far as why you missed it, and be prepared to, respond to that. So, all right. Paperbag Hero says, I got a debt collector claiming to be the attorney for the parent company of the landlord creditor. However, the debt was sold to NCS and they aren't listed on the lawsuit. Fraud, deceptive. So you see this, and I see this a lot with landlord tenant type collections. They seem to be a little more loose as far as what they do with things. Sometimes they'll hire these debt collection companies. They'll assign the debt for collection purposes only. Whether it's all legit, I don't know. The best way to do it is to file a response and maybe even a counterclaim. You may be able to file a counterclaim under the Fair Debt Collection Practices Act, the FDCPA, alleging that they are misrepresenting, that they own the account. But once you respond to the lawsuit, then, going back to that discovery, how you can ask for it in discovery, most jurisdictions require they provide what's called an initial disclosure to show how they got it. But if not, you can do discovery, get that, and that could help your case, down the road. So, all right. Rob says, what are my thoughts on Rule 106 when it comes to them submitting just a bill of sale? So Rule 106, these are the rules of evidence. And Rule 106, in most jurisdictions, what it states is essentially, we call it the rule of completeness as it relates to documents, where if you look at these bills of sale, look at the bottom. There's usually a page number on it or an exhibit. And sometimes it'll say like page 21 of 45. And I do object under Rule 106, essentially saying, Judge, they can't just take one page out of this big long contract and say, here's our proof. In fairness, you should be able to see the entire document. Now, they don't want to provide you the entire document because the entire document is the master purchase agreement or the forward flow agreement. Has a lot of information that they don't want out in the public as far as how much they're actually paying for these debts. And it's pennies on the dollar. That's how much they're paying. Not only that, usually in that much larger document, there is information on as far as disclaimers where they're saying, look, we don't guarantee any of this information that we're selling you, the dollar amounts, interest rates. We're not saying it's all correct. And so you can use that to try to get documents thrown out. So I think Rule 106, Rob, is a good one to use if it's something where they're only trying to give you just a little sliver. They've got to give you the entirety of the documents. So, all right, let's see here. This was a question from the YouTube channel. The YouTube channel, I have over, I think, 800 videos right now, and it's something where I can't keep up with the comments. So we have tens of thousands of comments. But this one was said, I have a question. Can I initiate a bankruptcy only with the 101 voluntary form here in Texas and then submit all the other schedules? The answer is yes. So when you file a bankruptcy case, it's usually a big stack of documents. It's about 100 pages thick right now in most cases. The document that gets things going, the initial document, is called the voluntary petition. The voluntary petition is generally about a 4 or 5 page document. Generally just has your information as far as name, address, social security number, just general contact information. And then you have to provide a list of your creditors. If you submit the voluntary petition, you will get a case number that invokes what's called the automatic stay. This is the rule or the law that stops all collections. So if you're dealing with repossession, foreclosure, wage garnishment, bank levy, whatever it is, even phone calls, letters, and snotty emails, it stops everything as soon as you file that voluntary petition, which is Form 101 that the person on the channel was talking about. And then you get 14 days to file the rest of the schedules. Schedules A through J, A, B, C, D, E, F. Okay, you get it. So all those schedules, you file them, and they each have information on real estate, personal property, all your debts, creditors are listed all there, income, monthly expenses, all that kind of stuff. So yes, but you can file just the initial petition, get the bankruptcy filed. 14 days later, that's when you're going to have to provide all the rest of the documentation. So, all right, let's see here. Rob had a follow-up, says, so far, that's what they're doing. It's providing just that one little sliver out of the big stack. If you get to this, I have one more. Okay. If they come to trial with no witnesses, but an affidavit, you need to object to that. Hearsay, it's hearsay. Affidavits are permissible like in Arizona, sometimes in arbitration. AAA will often allow affidavits. And an affidavit is just a sworn written statement from the creditor, from one of their witnesses. And in a trial type setting, though, you need to object because you'll see creditors do that. And some courts will even allow it if you don't object to it. But if they go up there and say, Judge, I want you to look at this affidavit, or we're going to have someone read from it. Objection, hearsay. It's textbook hearsay. Hearsay is just an out-of-court statement, which that is. It's a written out-of-court statement that's submitted to prove the truth of something. And the reason why, if you think about it, not only is it out of court, you cannot cross-examine that. So if they're submitting a sworn written statement, you can't go up to that person and test, the veracity of what it is that they're saying. So it's hearsay. It's textbook. The court should grant that, should sustain that objection and not allow them to do that. But like I said, sometimes you have to submit that, or it can be the court will just allow it. All right. Innocent Loyal says, do I have to respond to a motion to dismiss after I ask for a motion to dismiss? So usually the motion to dismiss, this is called motion practice in trials and in court hearings. So you file the motion. Most jurisdictions, they're going to allow you to file a response, and in most jurisdictions, they'll allow you to submit a reply brief. Now, you need to check the rules of civil procedure in your jurisdiction. So like in Arizona, you file your motion. There's roughly a 10-day response time and then a 5-day reply time. So it usually goes the person who files a motion, the response from the other side, and the person who filed it, they get the last say, and you submit a reply brief. So I typically do. You're usually limited to replying to what they put in their response. So it's not something where you can bring up new arguments that you didn't raise before, but you can respond directly to what it is that they are alleging. So, all right, Hercules says, I've been served with a complaint from LVNV Funding and responded with a motion for a more definite statement. The motion mentions giving the plaintiff 14 days to respond. This 14 days, let's see here. Okay, what? I've been served with a complaint from the period beginning when I file the motion, or does the judge need to grant the motion first? What are the steps in this process? So if you file the motion for a more definite statement, the 14-day window for them to respond. Clarification here. Does the 14-day period begin automatically when I file the motion, or the judge need to grant the motion first? Well, they're going to have a chance to respond to it, to the motion. So you file your motion for a more definite statement where you're saying, hey, court, I can't respond to this complaint. It's too vague. What you see a lot with debt collection complaints, because they're just boilerplate. They're just plugging names in and out. It's a lot of just kind of boilerplate language in there. So the 14-day period for them to respond starts from the day you file it with the court. You got to mail them a copy. They're going to have a 14-day window to file a response. And then, kind of like I said before, to the other question, then you'll have usually a reply that you can file. The court will then either grant it, deny it, or sometimes they'll set it for oral argument to allow you to respond to it. So that's typically what you can expect from that. All right, let me do a couple more quick questions. I had one other one. I get this question a lot. The compelling arbitration is a popular approach to this, but this person said, what is the perfect time to file the motion to compel arbitration? After filing the answer or during the court date in person? So I don't know if there's a perfect time to do it, but there is a time where it's too late. If you look at the arbitration clause in the terms and conditions on the credit card, often it will say if trial has begun or if judgment has been entered, you can no longer file it. I can tell you, just as a practice pointer, the sooner you file it, the better. I usually recommend, if you file an answer, file your motion to compel arbitration immediately after that. Do it sooner. Judges don't like it if you waste their time, if the case has been going for 7 or 8 months, and then you decide to file it. So I would file it sooner rather than later, just because it's more likely to be granted. It should be granted regardless, but I would do it sooner than later. And that's not to say if you're just finding out about this approach and you're 6 months into it, you can still file it. Like I said, the terms, look at the terms and the language in your arbitration clause. It usually says at any time during the litigation process, so long as the trial has not started or judgment has not been entered. All right, let's do one more here. I'll do a follow-up here with our innocent loyal. On that motion to dismiss, when does the judge make a decision? Usually after the parties have had a chance to respond. So you filed your motion, they file a response, you file your reply brief, and like I said, the court will issue either a written ruling and granting it or denying it, or set the matter for oral argument if the judge has questions that they want to address there. So, all right, with that, I think we'll call that for a night. Again, check out some of our sponsors, Solo Suit. The links are there in the chat section. I also put some links to Ascend Finance. If you're thinking of bankruptcy, one of the number one questions I get here in my law practice in Arizona is, do I qualify for a Chapter 7? If not, what's my Chapter 13 plan going to look like? I put some links to Ascend Finance. They have some free calculators that walk you through that and give you a good idea if you qualify, even before you have to talk to an attorney. Check those out. They'll help you out. If you want to meet with me, again, my scheduling links in there as well. I'd be happy to set up a call if you're in the state of Arizona and go over, where things at. And it is me. People are always surprised that it's me who does the consults. There is another attorney here in my office, but I do all the consultations. So I'd be happy to talk to you. And with that, we'll catch you.